All right, it is Drive Safe Day with Sir Rick and Dana Moore with the TXTA. How are you doing, Dana?
Well, I was doing good till I saw Mr. Trump there in prison. Rick, you guys are a hard act to follow, not to mention Miss Dolly.
Well, you know what? The contracts keep rolling in. We're going to close the deal on these today and make sure we make big money. So, Dana, I know you were on the show. Hey, great show on Friday. Last Friday on the panel discussion. Enjoyed having you. But today we want to focus a little bit more on what's going on here in Texas and what it means for the entire country. And I think that really goes down to the House Bill 19.
Oh, it absolutely does. In fact, it's basically become the model legislation for the rest of the country. It's how important it is right now. We got to keep in mind it's going to take probably a couple of more years before we actually start to see any results out of it. And here's the reason why. This thing went into effect September the 1st of 2021. And then what happened was right before it went into effect, these plaintiffs' attorneys went and just filed a whole slew of lawsuits to get around having to follow the House Bill 19 rules of evidence. And when you take that in conjunction with the pandemic, the court system is really backed up. So we haven't actually had, to my knowledge, a single case that's gone to trial under these new rules of evidence, but it's coming.
Why don't you just go right in and basically explain what House Bill 19 is and what it means, and let's just walk us through what it is.
Oh, absolutely. It enables a trucking company. It's not just a trucking company. It's any company that operates a vehicle. It could be a car, a pickup, or it could be an 18-wheeler. So it covers the whole gamut of vehicles that are used in the operation of a business. It allows when they get sued, it allows their attorneys to request what's called a bifurcated trial. It breaks it into two parts. Now, I use the analogy of a criminal trial, where you have a defendant who, in the first phase of his trial, will actually be found, him or her will be found guilty or not guilty. If they're not guilty, it's done. If they're guilty, then it goes to a second phase where additional evidence can be brought in, and the jury can determine whether, the amount of punishment for that person. It's very similar here. In the first phase, and this is what's really crucial, in the first phase of this bifurcated trial, the only evidence that can be brought in has to relate directly to one of two things: the negligence of the driver in operating the vehicle and the negligence of the company in maintaining that vehicle. And as a general rule, now there is one exception, it's a little lengthy to talk about, but nonetheless, it keeps these plaintiffs' attorneys from going on these long fishing expeditions and digging up stuff that has nothing to do with the crash. For example, they may be looking at inspection reports, roadside inspection reports from several years ago on another driver, another vehicle. And what they're trying to do when they do this is paint a picture of the company as being unsafe, a danger to the public. And if they can get that image put in the jury's mind, then they want the jury to, quote, send a message to this company and the trucking industry that, we're not going to take it anymore. So they really use it to influence the jury. So now the evidence relates directly to the crash at hand, the driver's negligence and the company's negligence.
Hey, Dane, I have a question on that. Let's break it into a company fleet. Is it possible that a driver can be negligent, yet the company not negligent? Have we seen any of that yet?
No, Rick, I haven't seen any of that yet. Now, here's what I am hearing from some of the trucking defense attorneys is that cases that have been filed after September 1st, when these rules of evidence, and that's what they are, rules of evidence, since it's been filed, they are much, much more likely to settle these cases than they were before. Before, they would ask for astronomical amounts, policy limits, whatever, and then they would go to trial. Now they're more hesitant to do so because they know they're not going to be able to pull, I'll call it the shenanigans that they were pulling before. All the trucking industry wants is a fair trial, a fair shake at it, a level playing field, if you will. And we haven't been able to have that in the past.
And I'm just going to ask you really quickly, Dana, how is this? This is actually one of the first steps to tort reform, right? I mean, this isn't really. This is actually an opportunity for us to create tort reform in this state.
Absolutely. In fact, on our legislative agenda coming up in January, we have about 3 or 4, maybe 5 tort-related items. I'll give you an example. We're going to be looking at advertising. You know, when you see the billboards and they put out this, you know, we just won $30 million, and then in real small letters, it tells you, it's on the commercials too, it tells you how much the attorney took and how much the expenses were and how little actually of the overall judgment that the injured party actually gets. So we're going to be looking at tort. We're going to look at something, and some of these get pretty complicated issues, but there's something called third-party litigation. And this is a business that has cropped up where Wall Street firms are actually funding these lawsuits. So it's turned into a business. So we're going to be looking at that and a number of other items as well.
Dane, I'm going to go on with that for a second, David. Give me a second. So, and I know you're not I'm not going to ask you attorney questions in here, but when it comes to kind of tort reform, or when it comes to the party that gets into the accident, let's just say the four-wheeler gets in the accident, are we, the trucking industry, are we giving up too quick to, are we fighting these the way we should? Are we scared to fight? And I guess what I'm saying on that is, if in fact a vehicle, a four-wheeler, is on the road, and let's just use the same instance, for instance, a truck. If in fact that truck, they run that computer on that truck and it's got sensors that are off and it wasn't roadworthy, well, the truck should have never been on the road. Are we doing the same thing with the four-wheelers? Meaning, are we going back and reading there, did they have an inspection? Were they being distracted? Were they talking or arguing with their spouse or friend, their kid in the back seat, that created a distraction on them as well to try to take that off? Or are we just, today, are we just scared and we're just making that deal as quick as we can?
Well, you're right. I'm not an attorney, so I can't address that directly, but I will tell you this. In the past, prior to House Bill 19, insurance companies were really more interested in playing defense. It was just cheaper to settle it. There was always that chance that should the jury go the other way, it could be catastrophic for the company. However, now with these rules of evidence that have changed, it's going to allow these defense attorneys for the trucking and business community to actually maybe go on the offense a little bit and be able to look at this. And let me give you an example of what I listened to last week at the TXTA Safety Management Conference. We had an attorney there talking, and he said, this is like the big brother, little brother situation. He said, little brother, hits big brother, and mom just goes, you shouldn't do that. But big brother hits little brother, she's all over him, And he said, that kind of equates to what we've had in the past with the car and the truck. The trucks are the big brothers, and the cars are the little brothers. And they pretty much get away with whatever they want to get away with. We hope that is about to change.
Wow.
How does how did there was a 6-year study by the Texas Department of Insurance. How does that play a role in these trials?
So far, I don't think it has. The reason that was in there is there were a number of legislators who really honestly wanted to not mess with maybe some of the trial attorneys who may have been funding them. So they tried to push the issue back over toward the insurance, which is not the problem. And so it's kind of an appeasement thing for these legislators. They created this study, 6-year study, so they could just see whether or not that was actually playing a part in it. We don't have any data from that yet.
Is it? And my end of the also. Right now, as it stands, I think that you can't even, if a person's injured in a vehicle wreck, and I'm just asking, we can't even admit that they were wearing a seatbelt or not, and they got, isn't that right?
That is correct. When the seatbelt law was passed, it was, there was some provisions in there that said you can't use it in a civil trial.
Wow.
Wow.
So that doesn't matter how unsafe they are, you can't use that.
Well, that's well, on the seatbelt issue, that's exactly right. But to Rick's point, I think we're going to be able to start looking at the four-wheelers, because we know that probably 75–80% of the crashes are caused by the cars, not the trucks.
Yes, we do.
So let's talk a little bit about everybody else looking inward at House Bill 19. This is really, House Bill 19's pretty much done a step toward the right direction, but other states are looking at this, right?
Absolutely. We get calls all the time, and we're working also with ATA, American Trucking Associations, and their legislative agenda. You know, we really would like to see some federal legislation where, depending on the amount of the lawsuit, possibly it could be filed in federal court. And this is because one of the reasons for House Bill 19 was the fact that in many of the urban counties around the state, the judges were, I hate to say it, but they sided with the plaintiff's attorneys almost every time. And part of it, I did mention a while ago, one of the things that House Bill 19 does is it allows for photographs to be considered admissible. And because what was happening was you'd have a picture of a car, a four-wheeler, with a scratch on it, just a scratch. And there would be a picture of it, and the defense attorneys were not being allowed to even bring that in to the jury so they could see the amount of damage. And that's crucial. And so we were able to get in there and say, all right, those pictures are admissible. Now the plaintiff's attorneys have to get in and fight to keep them out, which is a big difference. But it goes to the point that we have some issues with the judicial system and some of the judges in these, urban areas.
Do you have and that goes a lot to that says a lot to our ability to make it a fair trial, right? I mean, obviously, in these urban areas, we're not talking about equity, right? We're talking about you're fighting an uphill battle right off the bat.
Well, we certainly have been fighting an uphill battle. There's no question about that. All the trucking industry is looking for is a level playing field, a fair trial. If a truck injured someone, then the company and the insurance company should come in and make that person whole. And if there was gross liability, let's say that, God forbid, but let's say the driver of the truck was drunk and speeding, well, that's pretty gross negligence right there, and that's something that a jury would want to look at. But we don't want the facts of the case skewed exclusively to the four-wheeler or to the plaintiff's attorneys. It should be the evidence should be available, all of it, to the jury, and that's what I think we've accomplished.
Dana, we're in midterms right now. Early voting's happening right now. Is there anywhere that we can go to that our listeners, truck drivers, can go to that maybe some help from the TXTA saying, hey, here's the folks that are pro-trucking, whether we're endorsing them, anybody, is there any help on that just so we can pass it on to our listeners?
I don't know if that list is on our website or not. I mean, our endorsement is considered our check that we write to the various folks from, the governor, lieutenant governor, representatives, senators. I can certainly see if I can get that list for you, but I don't know if it's available publicly.
Gotcha. Yeah, if you can, like to have it. I know which way I vote, but you never know about Trump over there. He's kind of wishy-washy.
All my records in my
house. I'm out in Odessa right now. I'm out here. One of your other guests, Kenny Ray, and I are actually teaching a industry hazmat course the next 2 days. And Mr. Trump, I was out here 2 years ago at a rally that the White House invited us to, and I saw you, and I'm telling you what, Mr. Trump, I've never seen anybody work a crowd like you did. It was phenomenal.
Good job.
But I will say you probably need to work on your dancing skills just a little bit.
I'm going to try.
Good stuff on that, man. Love that stuff. Hey, love what you're doing out there for our industry, especially right here in Texas, and what we're doing with that House bill as well. Critically important, not only to Texas but to this entire country as we try to get this thing moving, towards that tort reform. Drive safe, Dave. Appreciate you. We're gonna get him to say the famous the words that need to be said.
Absolutely. All right, Dana. What I want you to do, I want you to state your name, who you're with, and that you're watching BCB Live, the safest station in the nation. Can you do that, sir?
Absolutely. Dana Moore with TXTA, watching or actually participating in BCP Live, the safest station in the nation.
All right. Thank you, Dana, man. We appreciate it always when you come on here and let us know a little bit about what's happened over there at the TXTA.